Now, remember, superseding cause is a cause that comes up between the time the plaintiff originally had something happen to them and the time they were hurt. For example, let's say that I bump a pedestrian in a crosswalk. All right? The EMT guys come and they put the person out on their gurney, and they're taking care of them, and they're doing all the things that they do, taking their vital signs, checking them out, and all of a sudden a truck comes barreling along and through the intersection and doesn't stop and bangs right into this plaintiff. Now, am I liable for the damages that are caused to the plaintiff by that truck? No, the second truck was a superseding cause. It's a cause that came up. Now, my bumping the plaintiff, in that case, it is not foreseeable. It is not foreseeable that a truck would barrel through the intersection far exceeding the speed limit and hurt the plaintiff again. And therefore, I wouldn't be liable for those damages. Now, the second plaintiff, the second defendant in the truck may very well be liable, and for sure. Anyway, now, a third type of defense is called, it's the plaintiff's contribution to the injury. Just turn your head a little bit, see that, to the injury. One is called contributory negligence. In that case, if the plaintiff contributes anything to their own injury, then no recovery. Okay? That is, if the plaintiff contributes anything to their injury, no matter how small the contribution, then they don't get a recovery. The second kind of contributory contribution to the injury is called comparative. Comparative negligence. And it's a percentage type of deal. Comparative negligence was pioneered by the state of California because the courts of California felt that if a plaintiff even contributed 1% to the damages, it wasn't right that they get nothing. If a plaintiff contributes 1% under contributory negligence, they don't get anything. Under comparative negligence, the court, or actually the jury, tries to determine what percentage what percentage the plaintiff contributes and what percentage the defendant contributes. And the plaintiff recovers the percentage of damage that the defendant contributes. For example, if I'm driving along and I make a turn without giving a turn signal, and a truck comes barreling along the other way and hits me, I've contributed to that accident by not giving a turn signal. On the other hand, my contribution may be only a few percent because that truck was barreling along at twice the speed limit and not paying any attention and on their cell phone. Their contribution to that accident may be 80%. So I might be able to recover 80% of my damages and not the other 20% that was my fault. The jury will weigh out those contributions and decide who gets what. Okay? Remember, contributory negligence, the plaintiff gets nothing if they contribute at all. Comparative negligence, the plaintiff gets recovery to the extent of the defendant's contribution to the damage. Okay, guys, that's it. good luck with this. Take care, and if there's any questions, send me an email. Thank you very much.